The other requirement is that of distinctiveness, that the color over a period of time should have achieved distinctiveness, right? That is, basically the customer can identify a particular color to basically mean a particular product. Now we come to the discussion on sound marks. Specify pitch and duration of sound, that is largely when they are represented on staves. Then you have possible form of actually electronic application of a sound file, right? So these are the various modes in which you can actually represent sound. But the question really is, are sounds capable of being registered? The answer to this was given by the courts in Shieldmark versus Justgest. Shieldmark actually held 14 trademarks, and some of the trademarks were related to musical stave, which contained the first 9 notes of the musical composition of Für Elise by Ludwig van Beethoven. 2 of these sound marks consisted of representations of the melody formed by the notes, that is graphically transcribed on the stave, plus in one case played on a piano. There were further marks which consisted of sequence of musical notes like E, D hash, E, D hash, etc. These were basically not put on a musical stave, but they were largely kind of symbols that are used to represent certain notes. There were further marks largely which were in the form of sequence of notes as such played on a piano. Now the question was someone else used similar kind of sound on their computer, which kind of included the onomatopoeia kukluku, which was protected by Shield's trademark, and also used Für Elise's notes when the computer was started. So Shield actually brought an infringement action against the defendant. So when the matter came up before the German courts, it was clearly a matter of great concern for the German courts, and the German courts actually kind of referred the matter to the European Court of Justice, seeking to know whether musical notes, whether written description in the form of onomatopoeia, whether written description in some other form, whether graphical representation of sonograms could actually be treated as graphical representation of sounds, and whether sound marks can be trademarked. Now the ECJ very clearly said in this particular instance, as long as the music is represented on a musical stave that clearly indicates the pitch and the frequency of the sound, then such a representation could be treated as a graphical representation because it meets all the criteria specified in the Reichmann case, and as such capable of being represented graphically. But any other form like representation of music merely in terms of notes or symbols, or in the form of word description of onomatopoeia like kukluku, cannot be treated as capable of being graphically represented, for the simple reason that there is an element of subjectivity involved in it, and that it does not necessarily meet the Reichmann criteria. So as far as sound marks are concerned, it is important to keep in mind that one needs to very clearly specify in their application for a sound mark that you are claiming a sound mark. 2, you are clearly kind of using a musical stave and the musical notes to clearly represent the frequency and pitch. Only in such an instance would a sound mark be granted. But the courts in other cases have also kind of said the graphical representation of sounds in the form of a sonogram, which clearly indicates the timing, the frequency, the change in the pitch, can also be granted a trademark for the simple reason that it is an objective representation of the sound and there is likely to be no subjectivity. Further, we move on to shape marks. Are shapes being capable of being granted trademark as such? This was a matter of great contention in the case called Philips versus Remington. Now, the Dutch company Philips came up with an electric razor in 1937. 2 years later, they introduced their first model to market, a single-headed rotary shaver. This was followed by a two-headed rotary shaver, and in 1966 by a three-headed product in which the heads were arranged in a triangular pattern which projected slightly above a triangular base plate. The three-headed model was sold under the trademark Philly Shave and soon became highly successful, accounting for about 30% of the world's electric shaver market. In the UK, Philips' annual sales of Philly Shave razors had reached about 2 million by 1989, and although this had fallen significantly to about 400,000 by 1996, they were still one of the major players in the market. But in 1985, in order to reinforce their monopoly, Philips registered a trademark consisting of a picture of three-headed razor in the United Kingdom. In spite of this, Philips' monopoly was finally challenged in 1995 when Remington introduced their own three-headed electric shaver. Not surprisingly, Philips sued Remington for trademark infringement, and in response, Remington sought to invalidate trademark on various grounds. In responding to the claim of the trademark infringement, Remington contended that the trademark registrations relied upon by Philips do not confer exclusive rights to use the trademark as a design for the faceplate of the shavers. Furthermore, Remington contended that it had not used the design as a trademark. So, in this particular case, the court said if a particular shape is taken to serve an essential function, right? That is, if the shape attained is to perform a particular technical function, in such an instance, the shape cannot be granted a trademark. The court said the ground for refusal or invalidity of registration imposed by the provision cannot be overcome by establishing that there are other shapes which allow the same technical result to be obtained. In order to be capable of distinguishing the shape of the article in respect of which the sign is registered does not require any addition such as an embellishment which has no functional purpose. Extensive use of a sign which consists of the shape of these goods may be sufficient to give the sign a distinctive character. So the court in essence here said that if you are registering the shape for a shape mark, one has to prove that it is capable of being represented graphically. It's capable of distinguishing goods of one trader from those of another trader. It is not devoid of any distinctive character, or if it has acquired a distinctive character through the use that has been made of it. Further, it does not consist exclusively of the shape which results from the nature of the goods themselves. That is one criteria wherein the shape should not have been from the natural form that the good actually takes. Second, shape mark will not be granted if the shape attained is largely to obtain a technical result. Further, the court said shape mark will not be granted if the shape attained is meant to give a substantial value to the good. Right? So this was largely the crux of the case in Philips versus Remington, where the court said the shape attained by Philips, that is the triangular shape with raised blades, was largely to perform a technical function. If it performs an essential technical function, then the shape will definitely not be granted protection under trademark as such. The other case that is of importance is the Lego bricks versus Mega Brands. Now, In 1996, Lego brands applied to register the red Lego brick as a three-dimensional mark for games and playthings. Now, the trademark office refused the application on the ground that the toy brick shape was devoid of any distinctive character. Second, the sign consisted exclusively of the shape of goods which was necessary to obtain a technical result. However, it was later approved. Following the mark's registration, Mega Brands Incorporation applied for a declaration that trademark was invalid.